the court to know that whatever had happened, it destroyed my life.
From a prosecutor's perspective, he is a murder defendant. He's not a child.
A teen charged with murder was seen smiling and even laughing on his way to court to face serious charges. Simeon Adams is accused of killing Nathan Trapezzino during what police describe as a 2-week crime spree. Adams is being tried in adult court and facing adult penalties. He could receive over 100 years in prison if convicted on all charges. Simeon Adams is no stranger to court, but this is his first experience in adult court, in chains, and facing a murder charge. The smile on his face might indicate that the teen doesn't fully grasp the pain he's accused of causing. 24-year-old Nathan Trapezzino was gunned down during an early morning walk. This is the surveillance video taken just before the victim's murder. Adams, who goes by the nickname Red, is charged with the murder, but his friends who attended the hearing dispute the charges against him.
Little Red, he innocent, he ain't do none of that.
How do you know?
How do I know? Get these cameras out of my face.
Prosecutors believe Adams was on a crime spree. On March 30th, he allegedly got into an altercation with a man at the Steak and Lemonade shop at 29th and Martin Luther King. In that case, he is charged with attempted murder and aggravated battery. Despite his age, the court is treating him as an adult.
From a prosecutor's perspective, he is a murder defendant. He's not a child. He committed a serious offense, has to be held accountable for the offense, and under the law at 16, he is an adult.
Adams has not yet hired an attorney. A hearing is scheduled for May 2nd to ensure that he obtains legal representation. Man murders parents. This is Russell Overland. In a shocking and tragic case that shook the small town of Mitchellville, Iowa, the mysterious disappearance of an elderly couple took a chilling turn when their remains were discovered in a tank just days after they vanished. Gilbert Overland, 81, and his wife Naomi Overland, 71, were last seen leaving their Sunday church service on January 28, 2007, and were never heard from again. Adding to the intrigue, Gilbert's son, Russell Lee Overland, 52, was also reported missing, leading authorities to suspect a possible connection between the two incidents. Just a day after his parents' remains were found, Russell was declared a material witness and was shockingly found on the run. The manhunt ended when the Northern Oklahoma Violent Crimes Task Force apprehended him outside a hotel in Miami, Oklahoma, a staggering 400 miles from his hometown. Russell was detained at the Ottawa County Jail and later transported to Iowa for questioning. In a chilling revelation, Russell confessed to brutally murdering his father and stepmother, showing a disturbing lack of remorse as he recounted the gruesome details.
Next time she comes through, boss, slap her. Unless she's the judge.
Forensic psychiatrist Dr. Charles A. Morgan III observed Russell's emotionless demeanor as he confessed to the heinous crime, vividly detailing how he ended the lives of his own family members. According to Russell's cold confession, he waited for his parents to return from church, launching a brutal attack on his stepmother Naomi as she entered the back porch. When Gilbert confronted him about the assault, the situation escalated.
If I come over to your table, does that mean I'm innocent? Just a thought, since my lawyer ain't showed up yet. He's probably stuck in the elevator somewhere.
Russell's motivation for such a heinous act was revealed to be rooted in the resentment he felt towards his parents for how they treated him at home. This tragic case came to a close when Russell Overland was sentenced to 2 consecutive life terms without the possibility of release for the brutal double murder. As the killer now spends his days behind bars in the Iowa State Penitentiary, the small community of Mitchellville is left grappling with the haunting memory of this unthinkable crime. It took only 52 minutes for the jury to come back with a conviction, finding both suspects guilty of first-degree murder. Despite the defense's arguments that there were no real eyewitnesses and no solid identification of the shooter, it's important to remember that the victim's son was in the back seat of the car at the time of his mother's murder.
I cannot wait to hold that little boy and tell him that the people who
his mother have been held accountable.
Family members say that when Rachel King's son learned of her murder, he repeatedly said that his mom was good and didn't deserve such a fate. He was in the back seat when she was shot 6 times. The shooter was hired by Julie Jean, whose obsession with the man who chose Rachel over her fueled the murder. In closing statements, the district attorney told the jury that vengeance is terrible, but in this case, it was deadly.
So thankful for all the hard work that paid off by everyone in this department. The DA's office, just incredible. We're thankful to God for just giving us the strength to go through this.
Rachel's parents both looked at the convicted killers, stating that they had stolen from them. However, they expressed that they had no choice but to forgive them, hoping that someday the killers would put their lives on a better path.
There really were no winners today. This was not a winning situation at all. My daughter is gone. This does not bring her back. We're glad to have memories of her, but my heart grieves, aches.
Zakim Al-Hakim and Julie Jean did not speak up for themselves during the sentencing. Both were sentenced to life in prison without parole, with an additional year added for their other crimes. We are at the Connecticut Superior Court in Hartford for the arraignment of Isaiah Benitez, who is facing first-degree murder charges in connection with the death of Felipe Lopez. The tragic incident occurred on Sigourney Street in Hartford on April 24, 2019, just 2 days before Lopez's 17th birthday. Benitez, already facing charges of assault and attempted murder from a March incident, turned himself into authorities 2 days after the shooting and confessed to killing Felipe. According to his account, Benitez had sent a text message to someone asking to buy $10 worth of marijuana at an address on Sigourney Street. When the seller arrived, Benitez approached the car's passenger side window, which rolled down, and told the teenager in the driver's seat that he was there to buy marijuana. The teenager then grabbed Benitez's left arm, prompting him to pull out a pistol with his right hand and fire 2 shots at the boy. As the judge was about to sentence Benitez for first-degree manslaughter, the courtroom took an unexpected turn. Juan Felipe Lopez's father and his twin brother suddenly lunged at Isaiah Benitez.
On that file, and the other file, Your Honors, for interfering in an FTA second, who's given a promise to appear on that file. He has 1 conviction.
Court officers quickly intervened, subduing Juan Lopez and his son before any further disruption occurred. They swiftly removed Isaiah Benitez from the courtroom to prevent an uproar. Juan Lopez, Felipe's father, was handcuffed by court marshals and escorted out of the courthouse. A former Hialeah police officer is set to be sentenced months after being found guilty of armed kidnapping. He is accused of kidnapping and beating a homeless man following a disturbance call at a bakery. He was acquitted of battery charges. Ortanio and fellow officer Lorenzo did not file a report about the incident, nor did they call their supervisor as protocol required. Lorenzo has been charged with the same 2 crimes as Ortanio, though his trial date has not yet been set. Ortanio faces a possible life sentence.
Months after being found guilty of armed kidnapping, Rafael Ortanio is accused of kidnapping and beating a homeless man following a disturbance call at a bakery. He was acquitted of battery. Ortanio and fellow officer Lorenzo Orfilia did not file any reports about the incident and did not call their supervisor as protocol requires police officers to do. Orfilia has been charged with same 2 crimes as Ortanio. His trial date has not been set yet. Ortanio could be sentenced to life in prison.
Jean Seckinger, the CFO of Parker Law Group, testified in the trial of Alex Murdaugh today. She provided testimony following questions about Murdaugh's financial crimes.
Question that the information that in part of the investigation where you and members of your staff and the forensic accountants determined that the clients did not authorize any of these transactions. I mean, you have no personal knowledge other than what's been told to you by people working for you or by the clients, right?
I also saw some of the deposits going into his personal Bank of America account statements.
No, I understand that, but whether the clients...
If they had some back deal, I don't know about any of it, no.
Right. And any information you have about what the clients told the firm is hearsay, as far as you know.
It's not hearsay if they said it to me.
Okay. And some said it to you?
Yes.
Okay. Thank you.
Miriam Clinton will spend the next 3 years and 4 months in prison for a hit-and-run incident that shocked the entire community. In court, the 29-year-old faced her sentence in Moma County Court after pleading guilty to third-degree assault, hit-and-run, and drunk driving. Just after midnight, a driver found Henry Smith, a Lewis and Clark student, seriously injured on Barber Boulevard. He had been hit while walking on his bike, which had a flat tire. Clinton turned herself in 6 days later. Before heading to prison, Miriam Clinton agreed to an on-camera interview, sharing a message for the victim and the community. She described the night of the incident as the biggest mistake of her life, made up of a series of bad choices. Clinton expressed deep remorse for her actions.
I'm losing my son, and I hurt somebody else, and this has affected so many people's lives in so many ways that didn't do anything to deserve it, and it's all my fault.
In an interview, Clinton answered our questions, spoke openly about what happened, and shared a message with the victim and the other driver. It was a very emotional interview. She expressed that she is a good person who made some bad choices. Officer Matthew Marshall is accused of inappropriate social media conduct and pleads not guilty to the charges. He is on administrative leave in light of these serious felony charges. The Brewster police chief stated that the allegations are offensive and do not reflect the department's values. Since 2007, Officer Marshall has sworn an oath to protect and serve the most vulnerable. He leaves court with no comment and faces charges related to using social media.
We're a first responder photographing of a scene. You did possess child pornography.
In court, prosecutors stated that Marshall had inappropriate videos of girls. The National Center for Missing and Exploited Children tipped off investigators, leading them to trace the content back to Marshall.
Image that was received in the tip, that phone number came back registered as the account holder of Matthew Marshall, resident of Brewster.
Investigators reported that while examining Marshall's social media data, they also found explicit videos of him.
Mr. Marshall is someone who has absolutely no prior criminal record, had a long career in law enforcement.
Officer Marshall admitted to investigators that the social media account was his, but he claimed that it was hacked.
I do think that the case is a serious case.
Despite his claims, Officer Marshall was put into handcuffs when the judge ordered him to be held on a $1,000 cash bail, which he later posted. Any devices he owns that can access the internet will be monitored by a probation officer.
He takes these allegations very seriously. He's married, he has 2 children.
The chief stated that an internal affairs investigation is underway to determine Marshall's future as a police officer. Emotional words were shared during the sentencing hearing for Edgar Suarez, the driver who drove drunk and hit an El Cajon family, killing 2 of them. The 33-year-old pleaded guilty to gross vehicular manslaughter and other charges. The victim's family members told the judge about their lives without their loved ones. The defendant received the maximum sentence of 14 years and 8 months in prison. It was an emotional hearing, with about 10 family members of the victim seated in the back row of the courtroom, visibly upset and crying throughout the proceedings. They clutched photos of their loved ones, adding to the emotional atmosphere.
Then immediately I saw my grandma laying down, and I also saw my brother. He was in his seat. I tried to wake him up. I talked to him, but he couldn't answer me, sir. No, I lived my whole life with my brother. We always shared rooms. And then that day was the first day when I called his name, he didn't answer.
إنه المحكمة تعرف إنه اللي صار هدم حياتي كلها.
I wanted the court to know that whatever had happened, it destroyed my life.
كان أملي بتخرج ابني هذه السنة.
I was looking forward for my son's graduation this year.
Near Rosecrans and Sports Arena BLVD, Edgar Suarez, the defendant, admitted to being drunk, high, and driving without a license when he crashed into a van. The crash killed 81-year-old Suad El Samari and her grandson, 23-year-old Ahmed Al-Rawi. Ahmed, as his mother mentioned, was in college just months after graduating with a cybersecurity degree. The hearing was filled with tears, as the family, who immigrated to the United States from Iraq in 2014, is very tight-knit. Family friends told the judge that Ahmed's parents may never recover from losing their son and his grandmother. The family is grateful for their pet, a German Shepherd named Cookie, who was in the van during the crash. Cookie was found the day after the accident, not far from the scene, and was reunited with the family, which was an emotional moment. The defendant did not apologize during the hearing, but his public defender spoke about his difficult upbringing. She explained that Suarez came from an abusive family and turned to drugs and alcohol because of his troubled childhood. The family expressed that while they are pleased with the maximum sentence, no number of years can ever bring back their loved ones. One particularly heartbreaking moment was when Ahmed's mother addressed the defendant, saying, "You took away my oldest son. You took away the person who first called me mother." It is Judgment Day for an accused drunk driver who crashed into a woman, leaving her paralyzed. The crash occurred in 2014 in Lighthouse Point, and the woman whose life was forever changed faced the driver in court. The victim took the stand and read an 8-page letter describing the profound sadness she had experienced since the accident. She spoke about her journey from being a physical therapist who helped others to become someone who was hospitalized for more than a year. For the first time, she came face to face with the man who forever changed her life.
First, let me say that contrary to how the press or the police reports have portrayed me, I'm overcome by grief over this situation.
More than 2 years after a DUI crash that left a woman paralyzed, 31-year-old Michael Angeli addressed the victim during the sentencing hearing.
Ms. Smith, with all the sincerity in my heart and all the humility of my soul, I apologize for what I've done to you.
Kim Smith, who worked as a physical therapist, was left paralyzed after the September 2014 crash. Smith was on her way home from work when Angeli hit her from behind in the 4,200 block of North Federal Highway. According to police, the impact caused her pickup to spin, go airborne, and slam into a tree in Lighthouse Point.
I'm infinitely regretful for the pain and suffering I've caused you physically and emotionally. Tortured by the torment I've subjected your son, grandson, and loved ones to, and beyond sorry for the inconceivable amount of shame and disgrace I brought to my own family and friends.
During the sentencing hearing, when a prosecutor asked Angeli what he had to drink that day, he refused to acknowledge what caused the crash.
I'll tell you that I was speeding, and I don't know that it's all right or not all right for me to go into the exact sequence of how things happened or not. I mean, my understanding is that it's not really my job to contradict anything that has been put forth in report.
Angeli faces a minimum sentence of 5 years in prison, but he asks the judge for a lighter sentence. In December 2015, in Butler County, Joshua Bradley Young took the life of Kinsley. When the police found Kinsley's body, they quickly discovered that Joshua was responsible for the terrible act. The prosecutor vividly described the complex and horrifying details of the incident, which captured significant attention.
State presiding is now in session.
Ladies and gentlemen, welcome back. Please have a seat. Jury is returned. Counsel and the defendant are present. We're on the record. I think I made that clear before we left. Both the state of Ohio and the defendant have rested. We've now heard all of the testimony, all the exhibits, and all the evidence. We've now been admitted. The next phase of the trial is closing arguments. The state has the burden of proof. The rules allow the state to argue first and last. As I told you the first day that we were here, statements of counsel are not evidence. The evidence comes from the sworn testimony from the witness stand and the exhibits that have been admitted into evidence. Closing arguments of counsel are designed to assist you. They're not evidence. All right, Mr. Moser, on behalf of the state of Ohio, you're prepared to argue?
I am.
Ready to proceed.
May it please the court.
Sir.
Counsel, ladies and gentlemen of the jury. First, I'd like to thank each and every one of you, as well as our alternates, for the time that you have given to this case. Now I have an opportunity to look you right in the eye instead of ducking around corners as we go to the elevator and whatnot around the courtroom and the courthouse. You will have a number of tools in your toolbox when you decide this case. Those tools will come from the judge in his charge to the jury. They're called instructions. And you learn from that that a trial is not a free-for-all on what you think the law should be, ought to be, might be, could be, what you might want it to be. It is what the judge tells you it is. So you'll learn from that how to apply the rules of evidence and law to questions of credibility, who's telling the truth, things like that. There are some tools that can't be in your toolbox, but in a case such as this, if we are now in the no-spin zone, you need, and I need, to tell you what I know and understand. You will want to consider, but you can't. I need to address those one at a time. Number one, how could anyone believe that a person would recklessly hurt a 2-year-old child? You all bring that in because you're all good people. You come from fine backgrounds. You wouldn't be selected for this. And you want to believe that nobody would do this to a child. And that's something that you hold in your minds and you have to fight to push back against, because you can't allow that to interfere with your decision and how you look at the facts of this case. The next benefit that a defendant has in a case such as this is how can sympathy be avoided for a hard-working, employed person? Is there any doubt that this defendant is a hard-working and employed person? You feel badly for that? Of course you do. And who wouldn't? That's what we want in people in our society, hard work. But you don't get a pass for that. You don't get a pass for that when you commit a crime. And that's what the state is asking you, the state of Ohio is asking you to find in this case, that a crime of was committed, not that he intended to, not that he even knowingly did that, but that he committed a reckless act of child endangering, using a child in such a way that it caused. Those are in the instructions, and they're very simply stated. So I'm not going to spend a lot of my valuable time going through what you are all capable of reading and understanding from the jury charge. It's in very simple, plain, ordinary language, and when you read it, you'll see it, and you'll understand what the specific charges are. You'll learn about evidence and circumstantial evidence, what it is and what it's not. You'll learn about inferences and what they are and what they're not. And those we ask you to apply in this case, but to leave the sympathy part alone. The next benefit that a defendant in this case has is that he is a veteran from Afghanistan, having served there. Having served there. Do you thank him for his service? You bet you do. Do I? You bet I do. Does any good American believe in our veterans and the service that they provide? Absolutely. But you can't let that fact interfere with your judgment in this case, because judgment is all you can do. Not decide this case on something such as that service. Is it a good thing? Sure. Does it play any role in this case? No. Unless you think it might, because after all, remember, his service was that of a medic who was supposed to be helping people fight pain, not causing a 2-year-old to experience more pain that child should ever experience. Lastly, you might say, with respect to the advantages it brings into a case like this, special circumstances of this case, you may say, well, isn't it enough that a failed mother has already been held accountable? Isn't one enough? Why does the state want more? Because in this case, the mother has been held accountable, but the person who caused this child to has not. Now, with all of that being said, and knowing that you will put all of those circumstances out of your mind with respect to those types of tools, this case is actually very simple addition. And I don't overstate it when I say that it is as simple as 1, 2, 3, and 4. Number one, the direct evidence is, and it is not an inference, it is direct evidence, that the defendant was alone with the child, when the child woke up screaming. And then the child went limp. And then the child and the defendant went to wake up the mother. And then the child goes out to the hospital for examination. Now, that is an immutable fact. It is direct evidence, not circumstantial evidence. And you know that, we discussed it more. EMT Peters and what the defendant told him. Next, at the hospital, we end up with that first critical x-ray of the brain, showing a minimal amount of swelling, perhaps some bleeding that might have predated that, but there was a minimal amount of swelling. And then 2 hours, 25 minutes, there's a whole lot of swelling. And all of the medical experts told you, which is uncontroverted in this case. Not one medical expert was called by the defense to rebut that abuse was caused. That abuse was caused, and as a result of that, the child, that is unrebutted, uncontroverted. Does anybody doubt it for a second? Of course not, because these are experts that deal with this. The Hamilton County Coroner. I would argue she had to be tremendously impressive, along with the radiologist, tremendously impressive, along with the pediatric doctor, impressively stated abuse was the cause, and the ophthalmologist who said hemorrhages in the eyes, those were caused from shaking. Now the judge is going to tell you that it is not necessary for the state of Ohio to prove whether it was shaking or some other assault. But what the state of Ohio has established is that the injury, and the coroner said to you, the injury was minutes, not hours. That's when the injury occurred, minutes, not hours, when that child went limp. Who was with the child when the child went limp? The defendant, mother, was off in the other room. The defendant had that child. You put those together, it is as simple as 1, 2, 3, and 4. I know it's sometimes, well, you see, making it too simple. Some cases are just that simple. Now, they're not that simple if you have an expert who comes in and says, oh, wait a minute, no, this wasn't abuse. This child's injuries were caused by falling off a chair. No, this was caused by even those minor little fender bender out in the community somewhere, where somebody either slammed down his brakes too hard to tell the child to stop screaming, or there was somebody that stopped in front of them and they had to stop the car real quick.
The defense's job in court is to prove the suspect's innocence. How did they attempt to do that in this case?
Where the detective told Brad he was already found guilty by the jury. He had already figured the crime out. I guess he did a trial in his mind, sat as the jury, and found him guilty. That's all. That's all. That's not the piece of work. That's just awful. Now, they were stuck with what they had at that point. They were committed. So now, let's look at the evidence. It starts with the doctors and what went on at the hospital. And there were a couple of interesting things. And first of all, the doctors, bless them, they're great. Most of them don't have a dog in this fight. Now, there was one doctor in particular, she was very honest with you folks. She said she's an advocate for abuse victims. She's all about it. She takes the stand with one thing in mind: convict who's ever sitting next to the Chabons. That's who she's going to convict. That's what your job would be, according to her. I respect the fact that she is so passionate about what she does. She saves lives. She comes in court, tries to do her best.
But when you look at Dr. Dylann, when you look at Dr. Correa, these folks were not here as advocates. They were here as doctors. So Dr. Simonson talked about the meeting that they had on December the 8th, the Tuesday following December 2nd, the Wednesday. And at that meeting were all the professionals involved in the case. There were police, there were doctors, there were social workers, approximately 30 people. But the interesting thing is, and Dr. Simonson was very honest, when she was asked about notes from that meeting to refresh her recollection, we don't take notes. We just want to make sure everyone is on the same page. Why? Why don't they take notes? She told you why. So they couldn't be subpoenaed. Well, why are doctors that are trying to figure out why a child worried about having their notes subpoenaed? Let the lawyers worry about that. Let the judge worry about that. Let the jury worry about that. They're in a hospital. But she wanted to make sure that everyone was on the same page. Now, I am not going to try to guess what was going on at that meeting, but I would think since the police were there, they gave their view. Well, we've got a mother, she's saying all these things. We've got a gentleman who's denying it. The doctor said, well, what is she saying? The police tells them. Oh, well, that could fit here, that could fit there. You know, the child's got a lot of marks and bruises on him. Well, you know now where those marks and bruises came from because the defense brought the witness in. Kinsley's great-grandmother. And she explained it to you. She didn't want to. And I can understand that. But she told you, and you heard her statement when she told you that Kinsley was really rough on herself. And that matched what Chuck Eastbot was saying. That Mike Rudy was saying. That the child was rough. The child had a lot of marks. That was Chuck Eastbot. But the point here is, this child was covered with marks and bruises and that kind of thing. Not from driving young. That's the implication. That's the inference that the state wants you to draw. That this man just literally beat this child every chance he had. Which wasn't really very often. You're going to have the work records of Bradley Young in the jury room. You're going to have a calendar. The calendar you're going to have clearly shows when Bradley was in town and when he was not. And that calendar is set up in such a fashion that the diagonals are work days, and when the days are circled, Bradley is at home. And if you count these, you'll find that this relationship, if that's what it's to be like, is 93 days long. And of those 93 days, Rebecca Kinner, Kinsley, and Bradley were together 29 days. No more than 4 or 5 days at a time. Now, when the mother of this child, if the mother of this child, felt that Bradley Young was in some way a danger, first of all, stay home with grandma and grandpa. Stay home. Just keep your child at home. Or if you want to be a little bit wild and crazy, you go, Rebecca, and let the baby stay at home. Let the baby stay at home with grandma. And then go party. It's only a couple of days a month. So then go be with the single guy. Do what you gotta do. If you're that concerned, leave your baby at home. But she wasn't. Shopping, together watching movies, eating, doing all the things that normal people do. So How afraid could she have been? How concerned could she have been? Now, I do not know what kind of mother Rebecca Kenner was. But in looking at the photographs of this child, the care that this child got was deplorable. You're going to have a picture of Kinsley's hands.
Charge of murder. We, the jury, being duly impaneled, find the defendant, Bradley Dean Young, guilty of murder in violation of Revised Code Section 2903.02B, an unclassified felony as charged in count 4 of the indictment. Appears to be signed by all 12 jurors. Jury for number 2, endangering children. Reads as follows. We, the jury, being duly impaneled, find the defendant, Bradley Dean Young, guilty of endangering children, a second-degree felony in violation of Revised Code Section 2919.22B1 as charged in count 5 of the indictment. Appears to be signed by all 12 jurors. Jury for number 3 reads as follows. We, the jury, being duly impaneled, find the defendant, Bradley Dean Young, guilty of involuntary in violation of Revised Code Section 2903.04A, a first-degree felony as charged in count 6 of the indictment. Appears to be signed by all 12 jurors. Verdict for number 4 reads as follows. We, the jury, being duly impaneled, find the defendant, Bradley Dean Young, guilty of endangering children in violation of Revised Code Section 2919.22A, a third-degree felony as charged in count 7 of the indictment. Appears to be signed by all 12 jurors. The defendant and counsel may have a seat. Counsel requests that the jury be polled.
Yes, Your Honor. Court, please.
Very well. Ladies and gentlemen of the jury, the court's going to call upon you individually to indicate whether or not the jury verdicts, as I just read them, is your true verdict in this case. Understood? You understand the question? Everyone's shaking their head yes. I'll start with what I consider to be seat 1. Juror number 883, did you hear the court announce the jury verdicts?
Yes.
Were those your verdicts in this case?
Yes.
Juror number 831, did you listen to the court read the jury verdicts?
Yes.
Do those reflect your verdicts in this case?
Yes.
Juror number 168, did you hear the court read the jury verdicts? Do they reflect your verdict in this case? Juror number 752, did you hear the court read the verdicts?
Yes.
Do they reflect your verdicts in this case? Juror number 547, did you hear the verdicts as read by the court?
Yes.
Do those verdicts represent your verdicts in this case?
Yes.
Juror number 315, did you hear the verdicts as read by the court?
Yes.
Do they represent and reflect your verdicts in this case?
Yes.
Juror number 755, did you hear the verdicts as read by the court?
Yes.
Do they, as read, reflect your verdicts in this case?
Yes.
Juror number 821, did you hear the verdicts as read by the court?
Yes.
Do those verdicts reflect your verdicts in this case, as I read them to you?
Yes.
Juror number 817, did you hear the court read the verdicts in this case? Do those verdicts as read by the court reflect your verdicts in this case?
Yes.
Juror number 558, did you read, or rather, did you hear the verdicts as read by the court?
Yes.
Do those verdicts as read by the court reflect your verdicts in this case?
Yes.
Juror number 481, did you listen to the court read the verdicts in this case?
Yes.
Do those verdicts as read represent your verdicts in this case?
Yes.
Juror number 765, did you listen to the court read the verdicts in this case?
Yes.
Do those verdicts represent your verdicts in this case?
Yes.
Does counsel counsel satisfied with the fulness conducted by the court?
Yes, sir.
Very well. Any reason why this jury cannot be discharged at this time?
No, Your Honor. Without thanks.
Very well. Ladies and gentlemen of the jury, you have heartfelt thanks to this court, this community, to these parties for your service. This time, the court will dismiss you with again our thanks and our gratitude. You are free to discuss this case and your impressions and your experience as jurors in this case. But you're free not to. You're entitled to be quiet. You don't have to talk about this case or your experiences with anyone. That's not your design. Understood? Now, another thing that I always tell jurors almost in every case is we have immunity here in the courtroom, and we can pretty much say whatever we want to say here as part of the case. Once we leave this courtroom, this case is over. Whatever we say, whatever you write.
Joshua Bradley Young was sentenced to life in prison with the possibility of parole. On February 22, 2014, in Golden Edge, Florida, Frash's body was found in the swimming pool of her home. Following a police investigation, her husband, Adam Frash, was arrested for the murder. In court, the lawyers for both sides present their cases from their own perspectives. The court listens to both sides equally, as no one can be deemed guilty until proven so.
So where was he when Gardner the gardener discovered the body of his wife in the pool? Well, after getting in at midnight with a 2- and 6-month-old child, having passionate sex with the woman he was just arguing with at Superlube and at the gate, then, by his own admission, arguing again in the middle of the night, around 4 a.m., this defendant gets up, packs up that black Yukon, takes the 2 girls, still in their jammies, and he's still wearing the clothes that he had on the night before, and they leave town at 8 a.m. So where does he go so early in the morning after such a late night with these 2 little kids? He first heads toward the home of a witness by the name of Martha Moore. Martha Moore is a woman with whom the defendant has a child, and she has kept his girls that he had with the victim, Samra Frash. She's kept the girls for him before. And on the way, once he leaves the gate, you'll see him leave the gate of Golden Eagle at 8 a.m. The first call he makes after he leaves the home that morning is to Martha Moore. And at the time, the phone location evidence is consistent with him traveling toward Ms. Moore's residence. And he tells Ms. Moore, "I'm on my way to your house." And she says, "No, you're not. I'm not there. I'm out of town." At that time, the defendant changes his plan. He goes to an auto parts store and buys a gas cap, and you'll hear a little bit more about that gas cap later. He says that was for his wife's vehicle. He tells Martha, forgot to mention when he was speaking to Martha, he tells her that he is giving his wife a break from the children, and he's thinking of taking them to Miami for a couple days. After talking with Martha, he goes to the Pep Boys auto parts store, purchases a gas cap, and he's on surveillance there, which you'll get to see. Then rather than heading to Miami, he heads toward Panama City, and we're able to verify this through the phone location information. On the way, he makes several calls, one of which is to a witness by the name of Luis Torres, to whom the defendant makes the statement, "Something really bad happened." He also leaves several voicemails for his wife, which you'll get to hear. She doesn't answer the phone, and she doesn't have any phone activity after he leaves the house or even throughout the course of that night before. Once in Panama City, he stops at Wells Fargo Bank, where he withdraws $5,000 in cash, which you'll see a video of that as well. He eventually gets a call from his friend, Kendall Lindsay, who advises him that his wife, Kendall has heard that his wife, Samra Frash, has been found in the pool at the Inverness Drive address. Interestingly, After being told of his wife's death, the defendant calls his wife again and leaves another voicemail. And you'll get to hear that voicemail. It's not, "Where the heck are you? Somebody just told me you're dead." So officers have learned that the defendant has a residence in Panama City, Florida. The Bay County Sheriff's Office is made aware of this, and they arrive at his residence in Panama City to observe the defendant, who appears to be loading items into the back of the black Yukon. The defendant is interviewed at the Bay County Sheriff's Office, and he makes statements. Statements including that his wife was hungover that morning and that she asked him to take the kids to give her a break. Now remember, she had sole custody of the kids, so he was in violation of a court order being in possession of the kids that day. He also offers statements about what he thinks happened to his wife, and one of the statements he makes is that he sure hopes she didn't trip over that hose. Why? Because she wears these cheap flip-flops and the little dog runs around the pool, and sometimes you have to chase the dog around the pool, and if she tripped over that hose and those cheap flip-flops, she could have fallen and hit her head and fell in the pool and drowned because she's not a very good swimmer.
Forensic doctors are highly respected in court. When the accused hears the details of the murder from these experts, they even feel the weight of their actions.
Yes, once the bone has been cut, this is a photograph that's taken from her right side. So the skull has been cut, and we're starting to remove the skull cap, and we could immediately see that there was hemorrhage here around the brain, underneath the skull.
And would there normally be inside your skull?
Not in this area. The blood normally would be in the blood vessels and not an accumulation of the surface of the brain.
States 82.
This is a photograph of the brain after it has been taken out, and this is looking at the bottom of the brain.
States 83.
This is another view of the brain. This is the bottom of the brain. What's lying in my hand would be the top of the brain. This photograph's demonstrating this area of blood that was in the subdural space, so between the brain and the skull. There's also here on the surface of the brain.
Which side of the skull of the brain is it?
This is the right side of the brain.
Is this a close-up of that injury?
Yes, this is a close-up of the same that was seen once we pulled the skull cap off.
And that's States 84. This is the right side, which is consistent with where the facial swelling was that we observed.
Yes.
States 85.
This is a photograph of the base of the skull. So after the brain has been removed, then I look at the base of the skull. So this is what the brain was sitting on, just to orient you. Here at the top of the photograph is the forehead. Under here would be her eyes. And then this is the central part of the base of the brain, base of the skull.
And where is the fracture in this photograph?
The fracture that I've shown you before, the linear one, occurred over on this side, the left side of the skull. Then it traveled here, and I could see that it came across and crossed the midline.
Okay. States 86.
This is a photograph. I'm putting a little pressure to show the fracture. Here's where it continued, came across, and continued across the base of the skull.
And could you get an injury like this from falling and bumping your head?
This is not from a minor impact to the head. This is a significant impact to the head to cause a fracture, not only of the side, but a fracture, basically, we'll call it a basilar skull fracture.
Did you find any injuries on her hands or arms to indicate that she put out her arms to try to catch herself while she was falling?
No, I did not see any injuries there.
State's Exhibit 87.
This is a photograph of her lung, and as part of the autopsy, all of the internal organs will be taken out and examined. And one thing we look for in cases is this, what we call froth, and her body was found in the pool, so I'm looking for changes that would indicate if she drowned or not. And this is one indication of drowning, and all of this is just frothy fluid that's coming out of her lung. So this is her right lung, and then this is the bronchus, the main bronchus, which is the main airway going to that lung, and this fluid was pouring out.
The defendant's lawyer tried various arguments to defend them. However, the truth was too strong to be hidden by lies.
He said a reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if you have a conviction, it is one which is not stable, but one which wavers or vacillates, then the charge is not proved beyond every reasonable doubt. And the instruction then says, and you must find the defendant not guilty because the doubt is reasonable. That instruction that we use and we've had in this country in this courtroom for years and years and years doesn't say you may find him not guilty, or you could find him not guilty, or you might think about finding him not guilty. It says you must find him not guilty because the proof is not beyond a reasonable doubt, and that proof was the obligation of the state. A reasonable doubt as to the guilt of the defendant in these cases may arise from the evidence, from conflicts in the evidence, or lack of evidence. In the 2.5, 3 years now that the state has had to put this case together, what you have is an awful lot of circumstantial evidence and speculation by the prosecutor as to what went on during the day and the days before the death of Mrs. Frosch. Hard evidence that we suggest to you clearly leaves reasonable doubt after reasonable doubt after reasonable doubt in this case is multiple. First of all, you know from the testimony of the young lady that came in that worked for the Housing Association or the Homeowners Association is that Golden Eagle is not an absolutely secure facility. That is, there are 3 entranceways into the property, and those are through unmanned gates, and you either have to have a code or you can tailgate somebody in. You can access Golden Eagle through multiple other sources by walking in from outside areas. We also know on the 22nd day of February 2014 that the Frosch home on Inverness Drive was not secured. According to Gardner's testimony, when he first arrives, 11 o'clock or thereabouts, he goes around back and the pool door is open. He enters. That's when he says he sees Mrs. Frosch in the pool. We know 10 minutes later, when Officer Womble arrives, that he goes through that same unlocked open door into the home. And then, because he's concerned about children possibly being there, he finds another unlocked and open door and enters the residence and goes and does a search. So that property, somebody had left that house unlocked, or somebody had opened those doors. Let's talk about the evidence in this case. Because I suggest to you the key issue is, when did Mrs. Frosch pass? How long had she been in that pool? We can talk about speculation and, oh, they might have had an argument, or, oh, they might have had this, said that. Oh, she might not have given the kids permission on other occasions to go off with her husband. But when did she die? And proof beyond a reasonable doubt in this case details specifically the time of death. Because what the defense has done, even though there's absolutely no obligation on a defendant ever to prove anything.
The judge always delivers a fair sentence, carefully considering both sides and all the facts.
Based upon the jury verdict in this case, I do adjudicate you guilty of first-degree murder, sentence you to life in prison. You do have credit for 372 days served in jail. As required by statute, there'll be $420 costs, $100 costs for prosecution. Reduce those amounts to civil judgment. Does that leave anything outstanding?
No, sir.
No, sir.
Mr. Price, you have 30 days to file notice of appeal. If you can't afford a lawyer, one would be appointed to represent you. Mr. Taylor, I trust you will discuss his appellate rights with Mr. Price, make a determination whether you intend to continue to represent him or whether he needs services of public defender or what exactly the attorney situation is. I trust you'll handle that with him.
Yes, sir.
All right. Anything else?
No, sir.
All right. We'll be in recess.
It sounds like the judge had to deal with quite a challenging situation. It must have been quite a scene in that courtroom.
Okay. All right. Miss Wills testified that you're being held on other criminal charges in the jail. Is that correct?
Yes, sir.
Do you have a hearing date or a release date for those other charges?
I have a release date on the 8th.
On April 8th?
Yes, sir.
You're expected to be released?
Yes.
Okay. Prior to February 16th of 2023, were you employed?
No.
Lie.
Okay.
Hold on a second. Just hold on. Ms. Bridges, was I unclear about not speaking or interrupting? Ma'am?
So what, y'all can shake a piece of shit motherfucking hand and say congratulations?
Hey, ma'am, if you go off like that, you can be held in contempt of court and go to jail. Do you want to do that?
Just proceed to the fucking court hearing and shut up.
Ma'am? One more outburst or one more vulgarity and you will be going to jail. You understand?
Good luck.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.